Good afternoon, members of the media, wider viewing and listening public of Trinidad and Tobago. Welcome to this week's post-cabinet media conference, which is actually the last one for this year, today being the last cabinet meeting between us for the year. And I have with me here today the Honorable Attorney General, who will address us this afternoon. Thank you.
Good afternoon to everyone and to Trinidad and Tobago. I'd like to report on the Cabinet's approval of the report of the Financial Intelligence Unit for the year ended September 30th, 2017. It's important that the population be made aware of the statistical information that Trinidad and Tobago is presented with coming from this very important entity, as it ties in specifically with a lot of the work that we have to do in the Parliament, and also some of the current issues being treated with, specifically in respect of crime and the management of anti-crime maneuvers and measures that the government has on deck. Permit me just to dive directly into the report and to point out that, firstly, this is a report which is to be laid in the Parliament. The next available date to lay this will obviously be in the month of January, as Parliament is on a temporary break, and therefore we're coming to the population now to inform of Cabinet's approval for the laying of this report, but to put these statistics in the public domain. The year in review from the Financial Intelligence Unit is the 2017 year. It specifically treats with the period coming to current point. There are several months that are obviously in this year which will be taken on board in the subsequent report. What's very interesting coming out of the Financial Intelligence Unit is, firstly, the reminder that this FIU is one of the reporting entities to treat with proceeds of crime, suspicious transaction activities, suspicious transaction reports as it relates to money laundering and particularly the financing of terrorism. It's directly related to the Financial Action Task Force 40 recommendations and the CFATF, the Caribbean Financial Action Task Force, monitoring of Trinidad and Tobago as we now stand in what we call enhanced review. It is, of course, linked to the observations of other entities, such as the Global Forum, and you will know that Trinidad and Tobago is in a position where it is the only entity in the world as a member of the Global Forum that has not met with compliance as a result of issues from the last government's failure to conduct any of the work that it was supposed to do. The FIU has reported some very astounding statistics to Trinidad and Tobago as contained in their report. Specifically, the FIU, which has on its list some 2,502 registrants. Those registrants are from various sectors: the banking sector, the commercial sector in the non-designated financial institutions and listed businesses. They include real estate agents, attorneys at law, pawnbrokers. A number of entities are required to report to the FIU. So with 2,502 entities actually reporting, we've seen this year that there has been a significant increase in the reporting entities as compared to 2016. First of all, in 2016, there were, in terms of suspicious transaction reports and also suspicious activity reports, the FIU received in 2016 739 reports. In 2017, they received 877. But what is extremely important is to note that the money value in 2016, the size of the money that was identified as suspicious transactions and suspicious activities, in 2016, of the 739 reports, that correlated to approximately $4.5 billion worth of suspicious transactions and activities. Here is the interesting point. In 2017, of the 877 reports, we are now at $22.1 billion worth of suspicious transactions. So the number has effectively gone up by 5 times. There's been a 500% increase. This must be pegged against the fact that, as you know, the budgetary workings of Trinidad and Tobago deal with an economic expenditure of $52 billion. So we're saying that $22.1 billion of suspicious transactions and suspicious activities have been reported to the FIU. Interestingly, in the number of transactions that were reported, they can be divided into two categories. Transactions which were completed, and what's the value of money for suspicious transactions that were completed, and very importantly, what's the value of suspicious transactions that were interrupted as a result of reporting. When we look to the number of transactions that were completed, we notice that of the completed transactions, 824 were completed. So there's a total of 877 reported. 824 were completed. Of those completed transactions, that represented a dollar value of $8.4 billion. 53 of these transactions, of the total number of 877, were what we call attempted transactions. And the value of those attempted transactions, transactions which were stopped as a result of reporting, is tied into a number of $13.6 billion. So 53 transactions amounting to $13.6 billion were stopped or interrupted as a result of suspicious activities being reported by the various entities. Across the financial sector, the entities with the greatest number of reports really came from the banking sector. So of the 877, we're dealing with the banking sector having made 387 of those reports. The money value transfer services, there were 325 reports there, and they took up the lion's share of the reports for suspicious activity and suspicious transactions. The FIU has very interestingly also demonstrated that there is a need for improvement in its mechanisms to combat this arena. And very importantly, the FIU has reflected upon the work at the Attorney General's office and the significant statistics that we have brought forward, specifically in relation to the financing of terrorism allegations, and that features into their report. But they have also requested for improved operational strength and improved legislative strength. And we wish to point out to the community, the larger national community and the international community that pays attention to these matters, that whilst the Ministry of Finance has provided for a significant build-out of resources in the FIU structure, which in fact has found very favorable mention in Trinidad and Tobago's follow-up reports in the joint group arrangements to the CFATF and FATF exercise. In that post-observation report that is produced by FATF and by CFATF, they have taken note of significant improvements on the operational strength structures at the FIU. But whilst that may have been the case, it is the legislative improvement, which you're well aware the government has been advocating and progressing, that really falls to further strengthen the fight against the financing of terrorism and specifically money laundering. And we must put onto the record that even though we are in Parliament right now on some of those amendments, on the miscellaneous provisions bill, in fact, you'd recall Dr. Munilal spoke quite recently on the bill. Dr. Gopi Singh spoke on the bill. Several members of the opposition have spoken. We have yet to have any form of support from the opposition on these matters. And this is a very significant point. The government intends, in treating with what has been identified as approximately $22 billion of suspicious activity in the Trinidad and Tobago economy, we intend to be laying into the Parliament in the month of January onward an anti-corruption package which treats with a number of the mechanisms that we can use to combat this particular scourge. That includes as you've heard on quite a few occasions, the standalone civil asset forfeiture provisions. It also includes amendments to the manner in which land is registered and maintained in Trinidad and Tobago, and certain fraudulent practices are driven out. But you would also have heard Minister Young speak, and as the report identifies that there are a number of politically exposed persons that have found themselves into the FIU's matrix of suspicious transactions and suspicious activities. But you would have heard Minister Young speak in the public domain about action which is being taken by the government on corruption, specifically including money laundering, cartel-type behavior as it's described in terms of explaining the type of operations, etc. And that includes action which is ongoing outside of Trinidad and Tobago. So there's Trinidad and Tobago police matters that are being pursued, and there is, of course, a civil matter that is afoot right now for recovery of corruption-driven transactions. And that is something which is to be added into this. So in the new year, you will certainly be hearing further details about the anti-corruption packages and the improvements that we're making. And secondly, further reports on the type of actions that are being taken in the courts of Trinidad and Tobago, both on the civil and criminal front. We must underscore that the opposition is to be carefully looked at in terms of their indication for support of any kind of legislative measure that the government drives. To date, we have noticed that we have not received the required support for the very important amendments that we bring. This FIU report is anchored in the anti-gang discussion because the suspicious transactions that have been unearthed by the FIU and are being investigated by the TTPS are in the hundreds. And permit me to actually give you a few of those particulars. It's interesting to note that the FIU is, in fact, it has completed, of the 877 reported matters, 647 fell into analysis, and those were completed. Of that 647, the FIU was able to generate 182 intelligence reports, of which 136 related to suspected money laundering, and 46 of them in financing of terrorism. Out of the 182 reports, 140 were sent to local law enforcement agencies and 42 were disseminated to foreign law enforcement agencies. Additionally, the FIU was able to complete some of its backlogging exercises. These suspicious activities and transactions are related, in fact, to a number of criminal associations, including gangs which have been identified in Trinidad and Tobago by the criminal and law enforcement agencies in Trinidad and Tobago, the new version of the anti-gang unit, etc. We've had that public discussion, but I want to underscore here that this issue is closely related to criminality as it prospers under gang legislation. And I've chosen to point this out by way of a reminder to the population to specifically underscore that some of the legislative measures which we have to treat with will require the support of the opposition. Some of it relates to the support that is required to perfect our obligations under the Global Forum, which treats with how the Council of Europe has recently managed to gauge Trinidad and Tobago and several other jurisdictions, 17 of them. But this kind of fight against money laundering and criminality is something that we have not seen support from the opposition on. And we therefore ask the population to consider carefully the growth in statistics. The growth between 2016 and 2017 is a growth of $4.5 billion worth of suspicious transactions to some $22.1 billion worth of suspicious transactions. The growth in the numbers from 739 to 877 between 2016 and 2017 is noticeable. The number of transactions that were interrupted by the FIU's reporting, as we've pointed out, is close to $13.6 billion, and that's only 53 attempted transactions equaling to that. Bear in mind that the FIU only effectively gains a snapshot. They don't have a full gamut of reporting. If you look to the report of the FIU when it is laid, you'll note, for instance, that there are only 658 attorneys at law that are reporting. The role of attorneys at law is much larger than that. If you look to money or value transfer services, there are 8 of them reporting. If you look to gaming houses, there's 1 reporting. If you look to the National Lotteries Control Board, of course, there's only 1. Building societies, there are only 2 reporting. If you look to cooperative societies, there are 184 reporting. Jewelers, only 166 report. Private members' clubs, only 102 of them report. And so therefore, we know that the figures are much larger. The drive by the FIU in terms of registrants is a significant drive. The director of the FIU and the FIU as an agency itself deserve a public commendation for the kind of work that they have managed to produce. It is directly associated to the support which the Ministry of Finance and the Attorney General's Office and the Ministry of National Security has given. We're very pleased to report that we have established a number of memoranda of understanding and connectivity for exchange of information on the local platform and also on the foreign platform. For instance, identification of owners of property and businesses, etc., via the Attorney General and Legal Affairs Division to the FIU is an ongoing process as a result of improved relations. So the direct improvement in the identification of suspicious activity is now before us, but we need to caution that this is something which features prominently on the government's agenda in the months ahead of us into the new year, and we're calling for public advocacy on this issue. I'd invite my colleague, Minister Young, to jump into this issue as well, because he can tie in the issue into some of the anti-corruption work that we're doing as well.
Thank you very much, Attorney General. You all have heard the very startling statistics, and in particular, that massive leap, as the Attorney General pointed out, a 5-time leap of what is effectively a sample, because it's not every transaction that goes through, for example, the banks that will be reported as suspicious transactions. So to go from 4 billion to almost 22 billion over the last year, we ourselves view that with some level of suspicion. Some of the work we've been doing in terms of following the money, it does not surprise us. This government and this administration is the first administration that has taken on the issue of active corruption frontally, and we've dedicated a lot of resources, time, effort into doing it, and we're doing it meticulously. And hopefully in the coming months, we will come back to the population to talk about some of the further findings. But as the Attorney General has said, and we repeat, we've also commenced action outside of Trinidad and Tobago, literally following the money on behalf of the citizens of Trinidad and Tobago in our fight against corruption. And this actually came as corroborative information and evidence for us that there is something that needs to be looked at and gone after. The only thing I'll add to what the Attorney General said is we've also picked up that organized crime in Trinidad and Tobago, for example, in the area of narcotics, they have to pay for products as well. And that is part of what we're seeing here. And this government, as well as law enforcement, are committed on behalf of the citizens of Trinidad and Tobago in doing all that we can to combat these scourges on our country. At this stage, we'll invite questions.
You mentioned the report spoke of politically exposed persons. What does that mean exactly?
Good question. So you do, by way of explanation, a politically exposed person includes relatives and lateral and vertical relations to persons who serve in public life. So sisters, brothers, fathers, mothers, children are caught by this loop, cohabitants, etc. So politically exposed persons identified in suspicious transactions have been flagged by the FIU. Obviously, this is something which involves as well some of the historical work, because we're now in a position where the FIU is cutting through the backlog. By providing the resources to the FIU, we have been able to tidy up the backlog. What we are doing right now is to make sure that we attack this issue on several fronts. Firstly, of course, the improved intelligence of the FIU is facilitated by increased numbers of persons. Secondly, the improvement in serious crime detection as it is defined under the SSA Act, because serious crime now includes all of these activities as well. That has provided significant intelligence which is able to facilitate law enforcement's activity. I'd like to, as we draw to an end this year, stop and just take a pin for a moment to give a very serious commendation to the Trinidad and Tobago Police Service and to the intelligence agencies in Trinidad and Tobago, because the population must by now be certainly recognizing that there has been an increase in the reaction time for arrests. Arrests for cash, which has been stolen at the airport, for instance. Arrests for murders, arrests for rapes, arrests for molestation, gang-related, what we can describe as gang-related activity, even down to obstructing the roadways in protests, the Trinidad anti-kidnapping measures. If you look to the closing of the gap of arrests now, we're seeing a definite trend upwards, and optimistically upwards, in terms of the reaction, and that has been facilitated by a significantly improved intelligence arena. And that, therefore, requires the population to say that we're heading in the right direction, as we genuinely believe we are. On the politically exposed persons, you are aware that there is anti-corruption work right now, which the Office of the Attorney General and certain state entities are pursuing. You will be informed of more action that will be brought to the public's attention in the coming year. This is an ongoing process. It is also noteworthy that we're treating with all allegations, and allegations, for instance, under the current arrangements of governance. So there is no fear or favor that is put, malice or ill will. All allegations are being investigated. Whether it is at the port of Trinidad and Tobago or elsewhere, you are seeing that the action is being taken in a fair and balanced approach by the relative and respective authorities.
Follow-up question would be then, how can you have effective anti-corruption legislation without defined campaign financing legislation beyond what limited legislation existing?
Sure. Well, you've hit one of the relevant topic issues. It's more than just campaign finance. The natural corollary to campaign finance reform, which, as you know, we are advancing, is public procurement. And you will see that we have advanced from the government's perspective all that we can on public procurement. We've amended the legislation. We've done the state enterprises and ministries outfitting of bodies to operate as procurement entities inside of each of these divisions. It was as a result of this, for instance, that Petrotrin itself was able to uncover activity that was worth investigation by this government under a board appointed by the present government. And that natural corollary is, of course, associated with campaign finance reform. Minister Young, in fact, was leading the charge on campaign finance reform, and we're in the process of drafting legislation for further consultative input with a view to bringing it forward to the population.
General, as you're on that particular topic, and given all that you've said about corruption, following the money, treating with all allegations, and even in the vein of politically exposed persons, could you perhaps give us your perspective on allegations raised recently by Udal Munilal about supposed money laundering in the fake oil scandal,
sure,
involving a particular individual by the name of Charles Diaz, who he claims has some sort of relationship with the Prime Minister. Is this particular matter something which is familiar to you, something which the government is looking into?
I was in Parliament when Dr. Munilal attempted to make a very scurrilous and scandalous allegation. when presented with the objection, he withdrew the allegation completely. I've noticed Dr. Munilal in the public domain now being very circumspect in his language to say that he has said nothing, but it's now out in the public domain. And what I can tell you is that the Prime Minister has spoken definitively on the fact that Dr. Munilal's allegations are nothing but complete, unadulterated lies, and that the Prime Minister has already publicly stated that he is looking for an opportunity to bring Dr. Munilal before the courts and anybody else who republishes this scandalous position before the courts. Our Prime Minister, as you know, has subjected himself through the years to open scrutiny. It is not lost upon me that the man that is making the allegations, that is Dr. Munilal, is the man who is fighting for his very existence. Every opportunity that we hear Dr. Munilal speak in the Parliament, he's really talking in his own defense. You really can't hear much more from Dr. Munilal other than that. Our position in respect of Dr. Munilal is that that matter will be dealt with in the courts of Trinidad and Tobago. With respect to the position, the Prime Minister has already stated the position. He has in fact stated quite boldly that the allegation alleging that there's some transfer to some account of his or Mrs. Rowley's account is so far from the truth, because there isn't even an account owned by either of them abroad or outside of Trinidad and Tobago. And therefore, it is not surprising that Dr. Munilal is being very circumspect and measured in his language right now, because he's obviously bold-facedly advanced a position which he's now afraid of. Because what he was attempting to say in the Parliament, which he withdrew, and what is being said on the outside now are chalk and cheese. So I have very little respect for the cowardice demonstrated by Rudal Munilal. He is someone that has distinguished himself in his ability to create some very scandalous allegations. You will recall the utmost pride he expressed in Vanilla Allen Toppin's attack on the family of the Prime Minister. You will recall his pride in what was carried in the media of hide your children from Keith Rowley. So this is a man that is viewed in a very particular way by some of us, and he is certainly not someone that I associate myself with in terms of being a paragon of any virtue.
You are obviously, as Attorney General and Attorney at Law, but also a Member of Parliament. The issue of privilege, because I did speak with Dr. Munilal about this at a press conference he had yesterday, and he's saying that once the statement is withdrawn, it's off of the record of the Parliament, and therefore no action can be taken against him or anyone else. What is the government's take on this? Because clearly the Prime Minister seems to have a different view.
The Prime Minister's lawyers are looking at the issue for he himself. This isn't, the government must be disaggregated from the individuals. The Prime Minister is no stranger to taking action against people and winning. He's been the recipient of umpteen awards for damages from several people in society. And I could understand why Dr. Munilal is now trying to hide behind, well, look, technically I withdrew everything. If Dr. Munilal is the kind of fellow that he pretends to be, saying that he's bringing serious allegations, I want you to remember, we heard Dr. Munilal on umpteen stage performances saying he has evidence. He is coming forward with something shortly. The only time that he brought that forward was in Parliament, and when he tried to move forward and was stopped, he then quickly withdrew. The parliamentary privilege which Section 55 of the Constitution offers is a very careful one. Privilege cannot be confused with the kind of abuse of privilege that Dr. Munilal sought to perpetuate against a sitting member of the Parliament, in this case the Prime Minister. But Dr. Munilal has really distinguished himself for failing to deliver on what he said he would, because he has not gone out into the public. So far, we're looking at issues broadly, and he has certainly been, he's certainly now in the position of distancing himself from what was said. That does not ring the type of truth or courage that Dr. Munilal said that he had on this issue.
I just wanted to, sticking on the same topic, would it therefore be saying that, because we know that Petrotrin is doing its own investigations into this particular matter, so therefore, in that context, would Dr. Munilal's allegations of potential money laundering in that particular matter, is that too far-fetched and maybe too premature, given that we have no conclusion as yet to those other
Well,
investigations?
I want to remind the population, Petrotrin stands apart from the government. The board of Petrotrin commissioned an investigation into the AV oil matter. It wasn't Mrs. Prasad Bisesa that commissioned that investigation. It wasn't Mrs. Prasad Bisesa that produced a report, and it wasn't Mrs. Prasad Bisesa that was taking advice on the outcome of those positions. It was the board appointed by the present government that took that action. What Mrs. Prasad Bisesa did was to get a copy of something which was not yet complete and bring it into the public domain. Mrs. Prasad Bisesa has on previous occasions done things similarly. Let me remind you, when Mrs. Prasad Bisesa brought forward the Central Audit Committee's report into life sport, she brought forward a premature report which went to the courts. Madam Justice Miradine Armorer, if I recall the judge correctly, considered that and said that there was no fair hearing and that the report was incomplete and premature. It was Mrs. Prasad Bisesa who then went on a celebration of the vindication of Anil Roberts to the point of offering him a senatorship to return in the present 11th Republican Parliament. So Mrs. Prasad Bisesa has a lot of experience in revealing reports prematurely, which then prejudice investigations. The board of Petrotrin, which is conducting this matter, it is that board which investigated this matter, and it is that board which will complete its investigation in this matter, and it is that board which will consider the advice of its attorneys at law and take action as is appropriate. The point to underscore here is that this government is prepared to investigate itself. And I'm not saying it, I'm demonstrating it by way of showing you the approach that was taken in the Petrotrin matter.
Just to add to that point that the Attorney General has made, you all would have seen recently, between last week and this week, yet another set of an example of fraudulent activity that we went in and we effectively investigated. We've gone to the court, we've frozen money. This is the East Port of Spain company. As soon as it was brought to our attention at the Office of the Attorney General that there was a suspicion of fraudulent activity, we immediately went in, investigated. Part of that is under this administration's tenure, and we do not hesitate to deal with it. It has now been passed to the police service. We've dealt with it on the civil side, and we'll continue pursuing it on the civil side. We have frozen accounts, and we're now going behind the money, and we're leaving the police service to do their work. These are just a couple of the examples of the work that this government will do with respect to corruption.
Permit me to give you one more example. You'll recall that there was an allegation in the Trinidad and Tobago Defense Force of theft that had occurred. It was the Office of the Attorney General that went to court, froze the accounts of the persons against whom the allegations were made, obtained admissions of guilt on the part of the persons involved, and it was long after the completion of the substance of the civil matter that the police eventually laid, if I'm not mistaken, 124, 142 charges. So the approach that we've taken in pursuing the civil side, as Minister Young just said, on the East Port of Spain matter, the civil side on the Defense Force matter, the civil side on allegations of corruption of past government members and boards of directors, these things have been going hand in hand with criminal matters, and that is evidence of it.
Afternoon, Janine Brown, CNMG. I wanted to know if you could clarify for the FIU report this year on the completed transactions, the 8.4 billion. If you could just clarify that the transactions are completed, does that mean that the money is irrecoverable, or?
Under the proceeds of, yes, so the transactions were complete, money passed. But if these reports which have been generated to law enforcement, both locally and internationally, if these transactions are prosecuted, if there's advice that they should be prosecuted, the money is recoverable under the Proceeds of Crime Act, certainly.
And the anti-corruption package, which you said would come in early 2018, does that require support from the opposition?
Some of the anti-corruption packages will require support of the opposition. For instance, under the Global Forum package, there are amendments to the Income Tax Act. There are amendments to the manner in which we treat with double taxation, etc. So there are certainly areas where we will require the opposition's participation and support, and then there are many others that will not require special majority consideration, which we will aggressively pursue in the Parliament.
Mr. Young, you had, in reference to Petrotrin, you issued a statement on Facebook concerning a Sunshine newspaper article referencing a particular issue, but the article also is raising a question about a conflict of interest concerning someone at Petrotrin, and what it says is a place that you are now having accommodation. You would like to respond or clarify?
As my statement said very clearly yesterday, there are certain issues that are my personal and private life, and the statement clearly said I will be resting it right there. So I have no intention in pursuing or prolonging any conversation in the public domain. Everything I do is with proprietary, and there is no conflict of interest. I didn't address these particulars of that article specifically. That can be done at a later stage by lawyers, but I have nothing further to say on it.
I'd like to point out, please, those persons who have a serious problem with Minister Young's immense capacity and ability, and in particular his very aggressive charge towards the anti-corruption matters, as the Office of the Attorney General is pursuing, will obviously do anything in their power to try and malign Minister Young. If you can't attack someone professionally and on their competence and ability, you must expect them to reach into your private life. There is no correlation, and the reason why we have a very efficient Office of the Attorney General is that Minister Young and I have come from private practice, and we obviously have conflicts of interest from time to time, be it in relation to a past matter that we handled, etc. Every time there's a need for us to recuse ourselves from treating with matters, we are not lost for potential or capacity because we are in good capacity at the AG's office. There are 3 cabinet ministers sitting inside of there, and this is something that obviously causes great concern and problems for people that have questions to answer. So I would like to very sternly approach this issue by saying that Minister Young has the full support of his entire cabinet team. There is no way that anyone can assail Minister Young's serious ability and passion for the work that he does between the Office of the Prime Minister and the Attorney General's office. And anybody who is raising any form of attack on anyone and their family members really has an ulterior agenda and really are to be viewed as cowards, because you are bringing personal issues that have no relevance to capacity or function.
Attorney General, by that argument, therefore, would you safely say that Dr. Munilal is in that category? Because as you were on the same tour with the Prime Minister when he made his comments about Dr. Munilal, and Dr. Munilal subsequently claimed that certain comments the Prime Minister made, he was being vulgar and possibly abusive, potentially abusive towards children, and setting a bad example.
We'll waste no more time on Rudal Munilal. He's not deserving of that kind of attention, respectfully.
The Prime Minister, when he was in opposition, did raise the email gate matter under the cloak of parliamentary privilege. We've heard from the acting police commissioner saying that the police investigation is over and that the matter, I believe, is now before the Director of Public Prosecutions. Dr. Munilal is saying that if the DPP determines there is really nothing to go forward with, he intends to sue for the money he spent on litigation. And the opposition is raising the question of whether the Prime Minister then was acting responsibly and so on. What is the government's position on this?
I'm very grateful you've raised the email gate issue. It's necessary to reposition and remind of a certain few factors. On the 20th of May 2013, Dr. Rowley approached the Parliament and revealed information which a whistleblower had provided and which he had, in the month of December 2012, taken to His Excellency the President George Maxwell Richards. Dr. Rowley explained that it was in the face of no action on the part of the Office of the President and in particular in relation to the Integrity Commission, that he brought forward matters. The matters brought forward were always in the context of whistleblowing information. And the Emailgate saga was tied into the Section 34 issue. The thread of 31 emails that dealt with the exposure in Emailgate essentially treated with certain activities which were tied into people being relieved from court matters by the proclamation of Section 34. In that Emailgate saga, there were two issues essentially. One, were there in fact emails of this type? And more importantly, was there any corroborative evidence about the matters and substance of what those emails spoke to? Did someone approach the Chief Justice and ask that the DPP be elevated as a judge? Were there tracers and spy equipment in the office of the DPP in the conference room? Was a reporter the subject of threats and harassment? I want to remind of those three specific issues. Was there criminality in the members of cabinet then constructed? The Emailgate position has been pronounced upon several times. It's not the first time this country has been told Emailgate is at an end, and it's not the first time that the UNC has called to arms to call for Dr. Rowley's head, and it's not the first time that the substance of the matter will have not been treated with. Let me remind, the past chairman of the Integrity Commission ended a case into Emailgate publicly. That was met with by resignations of Mr. Justice Sebastian Ventor, retired Justice of Appeal, and other members. The Commissioner of Police himself, the acting Commissioner of Police, previously said Emailgate was at an end. We have known now in the public domain that that was not in fact the case. Mrs. Prasad Bisesa herself called Emailgate at an end by bringing in a foreign expert to look at some computers. Nobody knows what was done or not. So there have been celebrations by the UNC on several occasions concerning Emailgate. What we do know is that the Commissioner of Police has said in a very nonchalant sort of passing way on a program that nothing of substance was in there. What Trinidad and Tobago has to ask itself is, what was being investigated? Is it the existence of emails? If that is the case, what period was the investigation looking at? I am aware that the period for investigation came about by way of a mutual legal assistance request on the 4th of November 2014, where Google was being asked to look at a very narrow window. It was being asked to look at the period August 31st, 2012 to September 30th, 2012. In other words, if there was substantive evidence of emails of the type put out that were in the month of July 2012 or in the month of October 2012, you would find nothing. So was the window narrow? What was being looked for? Was it a broad search over a period of time? The next very important thing is that Trinidad and Tobago has to ask the question, did the police investigation involve investigating the corroborative elements of the Emailgate saga? Did anybody approach the Chief Justice and investigate whether he had a conversation or there was an approach to him by a sitting member of the cabinet then with respect to the elevation of the DPP to a judge? I can tell you now, sitting in the post as Attorney General, that we have confirmed that SIS, through its ownership of EBSL, Executive Bodyguard Services Limited, replaced the security at the DPP's office. And I can certify now that there was a special branch report produced which demonstrated that there was infrared technology listening equipment capability in the conference room of the DPP. So that's a fact. We cannot forget that it was Mr. Justice Volney, as a member of Parliament, who came to the parliament and said that he saw the face of God in the Emailgate allegations, because nobody could have known what was said to him as he put it onto the record. So what we have to ask the country is to consider whether the investigation was as to the existence of emails per se, were there actual emails that said that, or was the substance of what Emailgate spoke about true or not, and more particularly, was that investigated? I am told that several persons were not interviewed by the Trinidad and Tobago Police Service as to the substantive allegations, and it may very well be that what the TTPS was looking at, I don't know, because I'm not a member, nor have I asked the TTPS about this. I don't know. I don't know if their investigation was solely, were emails on a server in the period August 31st, 2012 to 30th September 2012. Very importantly, the other question that must be asked is, were emails deleted because the wrong period was asked for? Because I am aware that Google cannot speak to material which was deleted prior in time. So there are a number of open issues on this table, and the Emailgate saga is far from over, because the substantive issues can be dealt with. I have just, as Attorney General, inheriting the portfolio that I have, I've just confirmed for you about the SIS situation and the bugging positions and special branch information at the DPP's chambers. It was a UNC government, Attorney General under the UNC, that changed the security services there. So this story is far from over. The question is, are we analyzing this thing correctly? What was asked? What was being investigated? And have the substantive issues been dealt with? I would not be as quick as Mrs. Prasad Bisesa is, and the persons that support her, to say that this saga is over.
A short time ago, you commended the police service for work it has done in the past year. I know you're questioning whether the police service conducted the Emailgate investigation properly.
Yes. What is surprising about that? One was in 2012 and one is in 2017. I'm commending the Trinidad and Tobago Police Service for the work that is afoot right now under this government, and I'm directly also attributing it to the improved Security Intelligence Agency functionality. I obviously am still not in any position to commend work that went on in 2012. I had no interaction with DCP Richardson as he was then investigating the matter, so I can see nothing confusing about that. There's no contradictory position.
So as a point of clarification, the comments you've been making, you made just now, would that be fair in the context of the matter now before the Director of Public Prosecutions, as far as we have been told by the Acting Police Commissioner, if I'm not mistaken?
Well, what the DPP considers is up to the DPP. There is a constitutional separation. The DPP enjoys his powers under Section 90 of the Constitution, and the Office of the Attorney General will not interfere in that process. I can only speak to my own estimations. I have put onto the table that I have not spoken to the Trinidad and Tobago Police Service about this matter. I have not spoken to the DPP about this matter, and I do not propose to do that. I can only speak from the positions of fact and information that I am personally aware of, and that's exactly what I've done.
So as you spoke about who you have not spoken to, in any of your recent communications with the Chief Justice on any matters concerning the administration of justice, have you had any conversation about some of the issues that have been raised in the public domain and recent newspaper reports?
What do you specifically?
Some of the allegations about security and some of the issues that have come up.
The executive in Trinidad and Tobago has a role with respect to judicial consideration and propriety in a very limited way under Section 137 of the Constitution. Section 137 of the Constitution has been used in the past by an executive. I'll remind you, it was Mr. Justice Sharma's Section 137 matter that a director of public prosecutions advised the Prime Minister to invoke. In this current scenario, we have received no such intervention by any entity, nor have we seen anything which yet takes us to the point of a trigger of a Section 137 intervention pursuant to the Constitution. In those circumstances, I can only take note of the conversation between the Law Association and certain elements in the legal fraternity and the responses coming from the judiciary, which clearly demonstrate that some responses have been given. The last time an executive took action under Section 137, the Prime Minister involved, Mr. Manning, came in for massive criticism by the UNC in particular. It was reduced to allegations of race, it was reduced to interference in the judiciary, and everybody lost the fact that it was a director of public prosecutions that told the Prime Minister to take the action that he did. Can you imagine the situation that we would be presented with if we were to act prematurely or without basis in this scenario? This is a matter which has to unfold, and the government will be very careful to observe the separation of powers principle and to act with propriety in this matter.
Thank you very much, members of the media. I'd like to take this opportunity, this being our last post-cabinet press conference for 2017, to thank you very much for working with us throughout the year, to thank everyone in Trinidad and Tobago for the continued support, and also to wish everyone a safe, happy, holy season. And we welcome and we look forward to 2018, where we think some exciting things will be happening. Thank you very much.
Can I just add my little small 2 cents? We are very optimistic about 2018. We think that a lot of the hard matters, hard decisions and adjustments have been dealt with by the people of Trinidad and Tobago with great success. We've come through a very difficult economic period, but we've managed it very well as a country. And the people of Trinidad and Tobago are to be credited and complimented on working on a situation together. We genuinely believe by the government's development program and our PSIP program and what we have in terms of maneuvers on anti-crime and economic growth, etc., that 2018 is going to be a good year. I would like the population to embrace the optimism that it really requires all of us to get this thing done, and that the government will do its very best. To the members of the media, thank you for your patience, tolerance, charm, wit, testing throughout the year. We value your input tremendously, and we also pay close attention to your points of view. Thank you.